The organizers may have a talk with the principal, because if he is late by say 15-20 minutes, then he may ask us to start it. So I would request Dr. Amulendu to speak to. Oh, he has come. Okay.
Okay. Okay, then should we start now?
No, has he joined?
I think sir has not joined yet.
Please speak once over phone.
Yes, sir. Hello. हाँ. अच्छा, just wait for a minute. Sir, principal sir is saying that he will reach within 5 minutes. Sir, am I audible?
Yes, audible.
Yes. Sir will reach within 5 minutes.
During that time, you may show your college performance from your website, or by sharing screen, or the association may show its own.
Okay, sir.
Many may not know. We can.
Then I will request Arnab Babu to make a brief presentation. Sir, will it be possible for you right now? Arnab Babu? Okay.
Sir, you can say something about library department, commerce department, and as a whole college.
Now, to whom you are saying, Shantanu Babu?
For all.
Okay. Okay, 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 okay. Good morning and welcome, sir. Okay. So should I start right now? Oh. Okay. Oh. Good morning to all of you. At the outset, myself, Dr. Amolendu Samanto, being a member of the organizing committee of this webinar, want to convey my heartfelt gratitude to all of you who are present in this web platform. And I also convey the greetings of Subho Vijaya to all of you. And this webinar on intellectual property rights is actually a joint initiative of Central Library, Department of Commerce, Hindi Shift, Banwarilal, Bhalotia College, and Indian Accounting Association, South Bengal Branch. So now I want to welcome our eminent speakers, Professor Joydev Sarkhel sir, Dr. Prem Kumar Agarwal, and Dr. Taroknath Sahu sir in this webinar. So I also welcome our honorable principal sir, Professor Amitabh Basu, and who is also the chairperson of this webinar. And now I would like to welcome the honorable dignitaries of Indian Accounting Association and my esteemed colleagues and other participants of the webinar. I also want to congratulate them for joining with us. And finally, I welcome the committee members, and without whose support actually this program would not see the light of the day. So now I request our honorable principal sir to deliver the inaugural address and to proclaim the initiation of the today's program. So now it is over to you, sir. Please deliver the inaugural address.
Professor Basu, you are muted.
Principal sir, please unmute yourself.
Okay, am I audible?
Yes, sir. Now you are audible.
Very good morning to one and all, and thank you very much, Dr. Amolendu Samanto. I am really feeling honored to welcome Professor Joydev Sarkhel, ex-professor, Department of Commerce, University of Bardwan, in our today's webinar as a concept note speaker. I would like to extend my deep sense of gratitude to sir for accepting our invitation. I would also like to extend a warm welcome to our distinguished speaker, Dr. Taroknath Sahu, Associate Professor, Department of Commerce, and Head of the Department of Business Administration with Vidyasagar University. I heartily welcome Dr. Prem Kumar Agarwal, HOD, and Associate Professor, Department of Law, Hooghly Mohsin College. We are really honored to have with us two eminent academicians and invited speakers in our today's webinar. I'm especially thankful to Dr. Arindam Das, University of Bardwan and Secretary, Indian Accounting Association, South Bengal Branch, for taking instant initiatives to collaborate our webinar with the Indian Accounting Association, South Bengal Branch, as and when we approached him. I also cordially welcome the other dignitaries and representative of Indian Accounting Association. As I can see some known faces, Dr. Professor Arindam Gupta, sir, and other dignitaries also there. I cordially welcome them also. My esteemed colleagues, participants, and dear students in today's webinar on intellectual property rights, organized by Central Library and Department of Commerce, Hindi Shift, under the Aegis of Internal Quality Assurance Cell of our college, in collaboration with Indian Accounting Association, South Bengal Branch. You all know that intellectual property refers to creation of the mind, everything from works of art to invention, computer program to trademarks and other commercial science. IP, intellectual property, covers a vast range of activities and plays an important role in both cultural and economic life. This importance is recognized by various laws. In different countries, there is a different laws for intellectual property right, and international law is also there for protecting the intellectual properties. The progress and well-being of humanity depend on our capacity to come up with new ideas and creations. The technological progress requires the development and application of new inventions, while a vibrant culture will constantly seek new way to express itself. Intellectual property right is very vital things. In this context, I want to mention one incident from my school life. At that time, I had no idea about intellectual property and even did not hear the term intellectual property right. one of my friends come with a very costly and nice pen and showed us and told us that his relative gave him this pen from Germany. At that time, one of my friends told him that if he had borrowed him that pen for 1 day, if he could borrow that pen for 1 day of Berlin pen, he would come with 2 pens next day, and challenged everyone that no one would be able to identify out of the 2 pens which one was made in Berlin and which one is made in Bardwan. That time I was in Bardwan. So from this incidents, we can easily understand how important is IPR, because a creation of someone which involves huge amount of time, his creativity, his huge effort, huge amount of money, and anyone can easily copy it within a very short period of time. So inventors, artists, scientists, and business put a lot of time, money, energy, and thought into developing their innovations and creation. To encourage them to do that, they need the chance to make a fair return on their investment. That means giving them right to protect their intellectual property, especially intellectual property rights such as copyright, patent, trademarks, can be viewed like any other property right. They allowed the creators or owner of intellectual property to benefit from their work or from their investment in a creation by giving them control over their property is used. So in present scenario, globalization, IPR is the focal point in global trade practices and livelihood across the world. This right boosts the innovative environment by giving recognition and economic benefits to creator or investor, whereas the lack of intellectual property awareness and its ineffective implementation may hamper the economic, technical, and social development of nation. You can imagine how important things. So it is a very pertinent topic. We are organizing seminar on a very pertinent topic. Hence, dissemination of intellectual property right knowledge and its appropriate implementation is Hello, any problem? No. It's okay.
No, sir. Please continue.
Okay.
You can imagine what important the intellectual property right. Hence, dissemination of intellectual property right knowledge and its appropriate implementation is utmost requirement for any nation. India lags in generation of IPR assets in terms of registered patent, industrial design, and trademark, etc. In a recent report published by US Chamber of Commerce, India stood at 29th position amongst 30 countries in the IP index around the globe. So it is very alarming condition for policymaker as well as for the nation as a whole. The development of any society directly depends on intellectual property rights and its policy framework. Lack of IPR awareness resulted in death of inventions, high risks of infringement, economic loss, and decline of an intellectual era in the country. Thus, there is a dire need of dissemination of IPR information so as to boost indigenous invention and development in the field of research and technology. At the outset, I really want to appreciate the initiative of our Central Library and Commerce Department Hindi SIP, and want to thank Indian Accounting Association South Bengal Branch for taking the initiative of organizing webinar in such a pertinent issue. We now looking forward to our eminent speakers to enlighten us on different aspects related to intellectual property right. At the end, once again, I want to thank all our respected invited speakers, dignitaries from the Indian and representative of the Indian Accounting Association, and participants, the members of our organizing committee for organizing this webinar, the member of our technical committee who is there for organizing this webinar smoothly, and last but not the least, Indian Accounting Association for collaborating with us. And I am also looking forward towards many such endeavors with them in future. I wish a grand success of this webinar. Thank you. Thank you very much.
Thank you, Dr. Amitabha Basu, Principal, BB College, and Chairperson of this webinar for such an enlightenment speech. I would like to introduce to the audience another dignitary named Professor Jaydev Sarkel. Professor Jaydev Sarkel is a retired professor of economics from Department of Commerce, the University of Burdwan, West Bengal. He is the president of Indian Accounting Association, South Bengal Branch. He has an extensive teaching experience of 40 years at UG and PG level and in academic administration. He has authored many research articles in different national and international journals of repute. He also authored several economics textbooks with wide popularity across the globe. He has successfully guided more than 25 research scholars. He is an outstanding academic record too. He stood first in the district among the humanities students at higher secondary level. He stood first class first in both undergraduate and postgraduate level from University of Burdwan. He is very active in the field of research till now. He regularly participates in different national and international level seminars, conferences, and webinars throughout the world in different capacities. I would like to invite Professor Jaydev Sarkel, sir, to deliver the concept note. It's over to you, sir.
Thank you very much for the introduction. Am I audible?
Yes, sir, you are audible.
Yes, sir. Okay. Respected Principal Amitaho Basu, the resource person Tarabnath Sahu, and Prem Kumar Agarwal, honorable members present in this webinar. First of all, I welcome you all in this webinar on behalf of myself and also on behalf of Indian Accounting Association South Bengal Branch, of which I happen to be the president. Now, it is a great honor on my part to be present in this webinar and to say something about the concept of intellectual property right. I must admit that I'm not an expert in this field, and therefore I will not be able to satisfy you on different aspects of the concept. I shall only give you a bird's eye view of the concept, and the other speakers will deal with the details, particularly the legal or accounting aspects related with intellectual property rights. Now, for my presentation, I will take the help of one presentation. Please wait. Is it visible?
Not yet, sir.
Not yet?
No.
Is it visible now?
No, sir.
Yes, sir. Now it is visible, sir.
Is it visible?
Yes, sir.
Yes. As I have already said, actually I shall give an overview on intellectual property rights. And in this case, I shall take the help of some slides. First of all, what is intellectual property?
তুমি কি কাজ করছো?
Intellectual
দেখে করো।
property.
আরে দেখো সব পড়ে গেল সিমেন্ট পিমেন্ট গায়ে। তোমাদেরকে একটু বললাম আজকের দিনটা
Shantanu, please unmute yourself.
As Amitav has already said, intellectual property is something produced using human intellect, which has commercial value. It is intellectual property. And property may be of two types. Property may be tangible property, or property may be intangible property. Now, intellectual property is actually intangible property. It cannot be touched, or it cannot be caught. But even intangible in nature, intellectual property is generally contained on a tangible fixed medium, such as paper, CD, compact disc, computer chips, etc. So, intellectual property is something which is produced by human intellect, and it has commercial value. It is valuable. It has commercial value. Otherwise, it will not be important. It will not be considered as property. And though it is intangible in nature, but it is usually contained on a tangible fixed medium, such as paper, compact disc, computer chips, etc. Now, what is intellectual property right? Intellectual property right is not to be confused with intellectual property. Intellectual property is something, but intellectual property right is a right vested in the asset and not the asset itself. The asset itself is not intellectual property. It is a right which is vested in the asset. For example, let us suppose that a scientist has invented something with his intellect. This invention is an intellectual property. But a patent registration for this invention is actually an intellectual property right. Similarly, let's suppose that a businessman or a business house has a price list or a customer list prepared by themselves. It is an intellectual property. But right of confidentiality, that this list should be confidential, it should not be shared with others, is an intellectual property right. Similarly, a secret production method, say production method of Coca-Cola, is an intellectual property. But the right of confidentiality or the right of trade secret, keeping that production method secret, not making it public, is an intellectual property right. Similarly, a particular way of representation is an intellectual property. But a copyright or a design registration is an intellectual property right. A brand name or a trade name, trademark is an intellectual property, but trademark registration is an intellectual property right. Thus, intellectual property right is a right with which we try to keep the intellectual property with us. We try to keep the intellectual property with the owner so that it cannot be misused by others. Now, intellectual property law is there. As Amitav has already mentioned, that there are certain national laws and there are also international laws on intellectual property. And let us see how intellectual property law works. The laws are such that a law allows owner to file a lawsuit against a transgressor. If anybody violates an intellectual property right, an intellectual property law, then the owner of the intellectual property can file a lawsuit against the violator, against the transgressor. But the law cannot stop a transgressor. It cannot prevent the transgressor. Only when transgression takes place, a lawsuit can be filed against the transgressor. This is how the intellectual property law works. Now, intellectual property rights can be divided into two major groups. On the one hand, we have the copyright. On the other hand, we have the industrial properties. In the copyright section, we have literary copyright covering novels, poems, plays, etc. We have also copyright in films, musicals, artistic, copyright in drawings, photographs, performing arts, sculptures, and software, computer software. There are specific laws regarding copyrights which cover all these areas. On the other hand, there are certain intellectual property rights which are applicable in the case of industrial or business concerns. These may be defined as industrial properties, and they include patents, industrial designs, trademarks, trade secrets, plant varieties, ICs or integrated circuits, and geographical indications. Now, all these are connected with the industrial or business concerns, and that's why they are referred to as industrial properties. Now, I shall give only a brief account of these intellectual property rights because it is not possible to give them in details. Consider first the copyright. In India, copyright is governed by the Copyright Act 1957, and the copyright is in original, literary, dramatic, musical, and artistic works. Copyright is also in computer software, engineering drawings, cinematographic films, and sound recordings. Copyright right includes the right to reproduce, make a copy, adaptations and translations as and when applicable. Usually the author gets a term, a lifetime of the author until 60 years following the year of death of the author. And broadcast reproduction right is 25 years. Performance right is 50 years. And what are the author's rights? Author's rights include moral rights of authorship and object to alterations. Resale share right in original copies. Copyright can be sold like any other properties. Some examples: literary works is novels, diaries, poems; musical works, symphonies, jazz, improvisation; choreographic works, dance, ballet; artistic works, paintings, engravings, sculptures; architectural works, buildings themselves; figurative works, maps, drawings, and charts of a scientific nature; cinematographic works, movies, video; photographic works, photographs and photo albums; program works, computer programs. All these are included in copyrights. And there are other categories of protectable works such as derivative works, compilations, etc. I am not going into the details of these. India has a very strong and comprehensive copyright law based on Indian Copyright Act 1957, which was amended several times in 1981, 1984, 1992, 1994, and 1999. And the amendment in 1999 have made the Copyright Act fully compatible with TRIPS, the trade-related aspects of intellectual property rights. And it fully reflects Berne Convention. The amended law has made provisions for the first time to protect performers' rights as envisaged in the Rome Convention also. With these amendments, the Indian copyright law has become one of the most modern copyright laws in the world. I'm not going into the details of the copyright. Now coming to industrial properties. The first one to mention is geographical indications. An indication used to identify agricultural, natural, or manufactured goods originating from a definite territory in India. It should have special quality or characteristics or reputation based upon the climatic or production characteristics unique to the geographical location. Examples of geographical indications in India are Darjeeling tea, Kanchipuram silk saree, Alfonso mango, Nagpur orange, Kolhapuri chappal, Bikaneri bhujia, etc. Very recently, we have also obtained GI registration for Nidana and Sitavog of Bardwan. Any association of persons, producers, organizations established by law or under the law can apply representing and protecting the interests of the producers. The registration of a geographical indication is for a period of 10 years and it is renewed after a period of 10 years again. India, as a member of World Trade Organization, enacted the Geographical Indication of Goods Act 1999, which has come into force with effect from 15 September 2003. The source of geographical origin of the biological material used in invention is required to be disclosed in the specification. Now, protection of new varieties of plants. This is another industrial property. And it is governed by the Protection of Plant Varieties and Farmers' Rights Act 2001. With this act, the the Act tries to provide for the establishment of an effective system of protection for plant varieties. New plants are invented and the protection of the rights of farmers and plant breeders is ensured with the help of this Act. And it is hoped that this Act will stimulate investment for research and development and will facilitate the growth of the seed industry. It will also ensure availability of high quality seeds and planting materials of improved varieties of farmers. Then we have the integrated circuits or layout designs of integrated circuits. It is governed by the Semiconductor Integrated Circuits Layout Design Act 2000. And the aim of this act is to provide protection of intellectual property right in the area of semiconductor integrated circuit or layout designs and for matters connected thereto. The act is implemented by the Department of Information Technology, Ministry of Information Technology. Next, we have the trademarks. Trademarks are governed by the Trademarks Act 1999. A trademark is actually any sign which can distinguish the goods of one trader from those of another. And the sign includes words, it may be logos, it may be pictures, or a combination of these. A trademark is actually used as a marketing tool so that customers can recognize the product of a particular trader. To register a trademark, the mark must be distinctive and not deceptive or contrary to law or morality, and not identical or similar to any other earlier marks for the same or similar goods. Take some examples. Trademarks may be fanciful marks or invented words such as Kodak for camera. Arbitrary marks having real meaning but no relation to goods. John Apple computers. Apple is an arbitrary word but not related to computers. Trademark may also be suggestive marks giving hint of the product, such as nappies. Sorry. Next, we have the brand valuation. The trademarks are very valuable and different trademarks have different values. We have given here the valuation of trademarks in Japan, not needed for us. India has full protection to trademarks under the Trade and Mercantile Marks Act 1958. And it has also been amended, and the latest is in Trademark Act 1999, which came into force on September 15, 2003. Next, Industrial Designs Act. Designs Act 2000. It is applied to any article of manufacture in 2-dimension or 3-dimension or in both forms. And this design, industrial design, is only for the appearance of the article and not for how it works. Design registration is intended to protect designs which have an industrial or commercial use. And duration of protection is initially for 10 years and extendable for another term of 5 years. Designs of stamps, labels, tokens, cards, cartoons cannot be registered. Next. These are not important. The existing legislation on industrial design in India is contained in the new Design Act 2000, and India had achieved a mature status in the field of industrial design and in view of globalization of the economy. The present legislation is aligned in view of the changed technical and commercial scenario and made to conform to international trends in design administration. Next, trade secrets or confidential information. Manufacturing, it includes manufacturing and commercial secrets. This must be secret, it must have commercial value, and there must be steps taken to keep it secret. It also includes consumer profiles prepared by any company, distribution methods followed by a company, manufacturing processes, advertising strategies, etc. All these are regarded as confidential information and trade secrets. And a trade secret, a typical example is Coca-Cola. The soft drink was invented in 1886 and was never protected by a patent. There is no patent of Coca-Cola. It is only protected by a trademark, by the name Coca-Cola, and by an industrial design for this very special design of the Coca-Cola bottle. The process of Coca-Cola drink is secret and is only known by 2 persons in the world, and they are not allowed to travel together so that there is no chance of them dying at the same time in an accident. The secret of Coca-Cola process was well kept during all these years, and nobody is able to produce a drink with exactly the same taste till today. You all know that Pepsi-Cola is the biggest competitor, but it has a different taste from that of Coca-Cola. So Coca-Cola has been able to keep its trade secret intact. Patent. A patent is actually a legal title granting its holder the exclusive right to make use of an invention for a limited area and time by stopping others from, among other things, making, using, or selling it without authorization. This right is granted to the inventor, and in return for this right, the applicant must disclose how his invention works in sufficient detail. When a patent is granted, the applicant becomes the owner of the patent, and like any other form of property, a patent can be bought and sold, licensed, or mortgaged. Patents are territorial rights. So an Indian patent will only give the owner rights within India and rights to stop others from importing products into India. So different countries have different patent rights. The patent right obtained in one country is not applicable in other countries. Now this is the details about Patent Act. I'm not going into the details. Now it is a myth that it is believed that intellectual property is high-tech, and so most business operators are not very concerned about the concept of intellectual property and intellectual property rights. But this is not true. World's first instant noodle made in Rhodes into the global market by way of patents. Mr. Momofuku of Nissin Food Products Limited, Japan, had embarked on a quest to create noodle that could be eaten anywhere with just a bowl and chopsticks. His research resulted in successful development of the world's first instant noodles, chicken ramen, in 1958. And chicken ramen turned out to be a big hit, and crude imitations appeared in market, but Nissan used its patent on manufacturing methods to combat counterfeit. Intellectual property by way of patents allowed Nissin to retain exclusivity. In fact, intellectual property is a tool to compete with multinationals. I'm giving only one example. The case of Gold Touch Technologies versus Microsoft. Gold Touch is a small company developed a keyboard, ergonomic keyboard, maneuvered into different positions to suit user needs and mouse design. Filed application for patents for its products and licensed it to Lexmark and IBM. Subsequently approaches Microsoft to discuss licensing. A year later, elements of the novel mouse design was found incorporated in Microsoft mouse, and Gold Touch started losing sales. Product branded with logo Microsoft were more acceptable than lesser known Gold Touch. Power of Microsoft logo greatly reduced potential sales of Gold Touch, despite Gold Touch design originality. Only because of the patent, Gold Touch could even think of stopping multinational Microsoft from selling patented product. This is the advantage of IPR. For most products, every form of intellectual property rights can be obtained. For example, suppose you have a camera. You can have a patent, you can have a design registration, you can have a trademark, a brand name or logo denoted as R within circle. You can have a copyright for instruction or manual booklet denoted by C within circle. These are the symbol of copyright. Similarly, in the case of CD player also. In fact, intellectual property is very important in the market because it differentiates one products and services from others. It promotes one products and services and creates a loyal clientele. It diversifies one's market strategies to various target groups. It popularizes the firm in foreign countries. It keeps away the firm's competitors or copiers. So intellectual property is a very important tool to capture the market and retain the market. With these few words, let me say thank you. I think I have been able to cover the entire aspect of intellectual property rights without going into the details. Thank you very much.
Thank you, sir. It was a very nice presentation by Jaydev Sarkar, sir. He has covered almost all the important areas of intellectual property. Now, Arif sir, please come. So, shall I introduce Prem sir?
Santanu sir, please introduce Prem sir.
Okay. Okay, so Jaydev sir has covered different areas of intellectual property. So now I would like to invite Professor Dr. Prem Kumar Sao, HOD, Department of Law, Hooghly Mohsin College.
No.
Yes.
Shantanu sir, now Taroknath Sao sir will speak at first.
Okay.
Yes.
Okay, hello. So please introduce Taroknath Sao sir.
I would like to introduce Taroknath Sahu. Dr. Taroknath Sahu is currently working as an associate professor in the Department of Commerce and head of the Department of Business Administration, Vidyasagar University, Midnapur. He has over 14 years of postgraduate teaching and research experience. His specialization is in the finance, financial economics, and his research publications are in the areas of corporate finance, corporate governance, stock market, etc. Dr. Sahu, a gold medalist at both graduate and postgraduate level, has authored 4 books published by Springer, New York and Emerald Publishing Limited, UK, and edited 6 books. He had already completed 2 research projects sponsored by UGC and ICSSR under the IMPRESS scheme. Under his supervision, 6 researchers have been awarded their PhD degree. Dr. Sahu has published more than 90 research articles in reputed national and international journals published by different reputed publishers, including Springer, Blackwell, Emerald, Taylor and Francis.
Lack of IPR awareness resulted in the death of invention, high risk of infringement, economic losses, and decline in the intellectual era in the country. Thus, there is a high need of dissemination of IPR information so as to boost original investment, invention and development in the field of research and technology. So, in this context, the organizer rightly chosen the topic to discuss on intellectual property and its different aspects in right time. Also, my respected teacher, Professor Joydev Sarkar sir, nicely introduced the topic intellectual property right. And within the next couple of minutes, I will try to highlight the different types of IPR, obviously in a befitting manner. Then the Indian position on IPR in the global scenario. After that, I will try to highlight the different valuation method of IPR, and finally a brief discussion on accounting aspect of IPR. Before start my deliberation on IPR, let me share the slides. Yes. Intellectual property rights are legal rights that provide creators protection for original work, invention, or the appearance of product and so on. Already Professor Joydev Sarkar sir discussed about this. The intellectual property rights are intangible in nature and gives exclusive right to inventor or creator for their valuable invention or creation. In present scenario of globalization, IPR is the focal point in global trade practices and livelihood across the world. These rights actually boost the innovative environment by giving recognition and economic benefit to creator or inventor, whereas the lack of IPR awareness and ineffective implementation may hamper the economic, technical, and societal development of a nation. The most common IPR includes, say, patents, trademarks, industrial design, layout design, geographical indications, copyright, uh, copyright and related rights also. These are the main the form of intellectual property rights. And regarding patent is an intellectual property right granted to inventor by concerned government official for his novel technical innovation or solution of any problem in terms of development of product or a process also. The patentability of any invention need to fulfill some criteria like usefulness. Innovation must have industrial applicability or applied for problem solving purpose. Then second one is the novelty. It must be new technology which has not been published or available elsewhere in the world before the date of patent filing. And third one is non-obviousness. Hence, the invention must not obvious for patentability. As per Section 3 of the Patent Act 1970, the following are not patentable, like invention against the natural laws, invention which are not fair or to health or of human, animal, plant life, environment as well as country, etc. And discovery of any living things, and invention relating to atomic energy and related to security of the particular country. These are not these invention is not treated as patent as patent as per the Patent Act 1970. In India, Office of Controller General of Patent Design and Trademark govern the patent registration process. This office comes under the Department of Industrial Policy, Policy and Promotion Ministry of Commerce and Industry. The owner can exploit these rights by industrial production or can sell, distribute, or licensing the rights as per his will. The right of patent are granted for 20 years, and once the patent expires, then invention enters into the public domain and anybody can use the knowledge. And regarding industrial design, the creative activity of achieving an ornamental or aesthetic appearance of mass produced products or articles is covered under industrial design. The aesthetic value of how product appeals is the main concern in selling beside the technological quality and other aspects. And industrial design encourages creativity and skill design among the individual and manufacturing sector by promoting more aesthetically pleasing product for the society. And the design or shape of the product not only create aesthetic appearance, but in case of say machine, furniture, automobile, etc., design is also indirectly associated with ergonomics and plays a major role in customers' comfort also. Regarding again the industrialization, with the industrialization, the trademarks become key factor in modern world and international trade. Trademarks is a distinctive sign or logo that denotes about the particular item is produced or provided by a specific person or industry or enterprise. Similar to trademark, service mark distinguish service providing enterprise with their competitors. trademarks or trade name helps competitor to make their recognition, reputation, and trust among the customers. In most of the cases, customers rely on trademarks where it is difficult to inspect a particular product or services quickly to determine its quality. A particular, basically a particular segment of customers is very much concerned about the brand and pay heavily for brand prestige, even for a similar sort of quality of to distinguish themselves from the crowd. Then layout design is another form of IPR. In the present era, life cannot be thought of without electrical or electronic gadgets like mobile, smartphone, laptop, computer, cameras, etc. All applicants are very compact nowadays due to their integrated circuit. And beside this, most of the instruments having microprocessor based control or operating system make up the integrated circuit or layout design. These design of circuits are creations of human mind as a consequence of enormous investment and efforts of high quality experts. The original and inherent distinctive layout design can be registered as per the Indian Semiconductor Integrated Circuit Layout Design Act 2000 for 10 years initially. Then regarding trade secret, the invention or knowledge which is not innovative in nature or not patentable but useful for business and provides economic benefit can be kept as trade secret. Beside this, novel or creative information is also kept as trade secret when registered of patents, copyright, industrial design, etc. are patenting or in process, are pending. They applied for the patent, but it is under process. Then it is also becoming trade secret. The technological information or process such as recipe, idea, device, software, blueprint, pattern, etc. are under the trade secret. Jay sir already illustrated these things very nicely. The next one is geographical indications. GIR signs. These are various signs used on say goods that have a specific geographical origin and process quality or reputation that are due to that place of origin. Actually, in some agricultural products, the agricultural products typically have qualities that driven from their places of production and are influenced by specific local factors such as climate and soils, etc. Yes, sir already shared that Darjeeling tea, Alfonso mango, etc. are the example of geographical indication. Similarly, in the field of handicraft, textile, etc., specific qualities of the product and related with human factors and their skills also. In case of handicraft, textile, there are some geographical indications are there. We know that say Dhaka muslin, Kullu shawls, Kashmiri handicraft, etc. are the known example of geographical indication. In the field of handicraft, textile, etc. Then copyright is a legal term describing rights given to creators for their literary and artistic work. It includes literary and scientific works, musical works, artistic works, photographic works, motion picture, computer programs, etc. Okay. While if we see the rank of India relating to intellectual property right in the globe, then we can see that intellectual property contribute from the table. Actually, from the table shows that India has been ranked as 46th place in the global global innovation index 2021 released by the World Intellectual Property Organization. Though among the lower middle income group, India has become ranked at the second after Vietnam. The Global Innovation Index 2021 considers the innovation ecosystem ecosystem performance of 132 economies and track the most recent global innovation trend. Again, if we consider the second table, as per the International Intellectual Property Index released annually by US Chamber of Commerce Global Innovation Policy Center, India ranked 40th among 53 global economies. The Intellectual Property Index evaluates each economic ecosystem based on 50 unique indicators. And so as per the indices, India has shown real improvement over the past few years. However, right holders in India continue to face substantial challenges, particularly regarding the patenting environment, in which the Indian policy framework continues to deny patent eligibility to a broad range of innovations. Different reports also suggest that economies with the most effective IP framework are most likely to achieve the socio-economic benefits needed to combat COVID-19 also, including greater access to venture capital, increased private sector investment in research and development. Yes. Regarding IP valuation is concerned, the valuation of IP assets has consequently grown in importance, as this become a major part of many companies' value and a driver of important market transaction. IP valuation is the process of determining the value of intellectual property such as patent, trademark, copyright, and trade secret, etc. If anyone plan to buy, sell or license IP, he need to carry out an IP valuation to understand the value of the IP assets. Valuing an IP asset is usually a means for achieving a broader goal. The main purpose for undertaking an IP valuation are, say, technology transfer by licensing or sale or purchase. In this case, the valuation process supports the negotiation process. During the negotiation process, the parties will aim to agree on an acceptable transaction value. So we need to determine the value of the intellectual property for transfer of technology or to give license to any third party. The second one is, in case of, say, merger and acquisition, we need to merger, acquisition, or joint venture and strategic alliance also, we need to calculate or determine the value of IP, intellectual property, to determine the value of the firm at the time of merger or acquisition. Again, say in case of financing or bank loan collateral, we need to calculate the value of the IP before the financing. The bank should know the value of the IPR. The next one is insurance for IP assets. It is a completely new market is opening for the insurance of IP assets, with a number of major insurers in the developed countries creating products tied with the capital value of IP assets. So determine to determine the premium for the insurance of IP assets, we need to determine the value of the intellectual property. And next one is say research and development decision making. When a particular firm take a decision whether to continue investing in research and development or not, they need to determine the value of the IP as well as the cost of developing the intellectual property. That's why in case of research and development decision also we need to determine the value of the IP. Then a calculation of say damages, to determine or to calculate the value, the damage of say IPR. We need to determine first the value of the IPR, the intellectual property, and for the taxation purpose also we need to calculate the value of the IP. For accounting purpose, accounting, financial reporting, and investor relation, we need to determine the value of the intellectual property. Further, it is important to note that IP assets do not have absolute value. They may have different valuation results depend on how they can or will be put to commercial use and by whom. Furthermore, a valuation exercise can be inherent subjective. There are a number of factors that plays a key role in IP valuation. The expected economic benefit is usually influenced by legal factors, technological uncertainties, and market forces. The different variables which may influence the value of IP assets include, say, valuation context, the reason why the IP is being valued, the benefits expected to be generated by the IP assets, and who stands to benefit, etc. So valuation context is the important things for determining the value of intellectual property asset. Then time, the moment in time when the valuation is being carried out, for how long the IP right will be held. This is very much important in case of IP valuation. Then legal status, say it is registered or unregistered IP, strength of the IP rights, infringement issue, etc. Comes under the legal status of the IP. Then external variables such as existence of legal, technological, and market uncertainties when say estimating the future economic benefit of the IP assets, geographical reach, and other different factors like tax matters, interest rate also influence the value of the intellectual property. Okay. Again, there are many ways for IP asset to generate economic benefit, and IP asset can also bring economic benefit by providing license or sold to third parties, that is by providing access to the market or by creating barriers to entry to competitors among others. IP monetization can thus be either direct or indirect, and each mode of monetization has its own valuation context. In direct form, an IP asset can bring economic benefits through IP trading, licensing, and exchange. Whereas in indirect form, the IP monetization can be possible by applying the IP assets to products or services which are then sold to customer. So indirect IP monetization is simply the conversion of IP into products and services for the business or consumer market. The key role of IP in this mode is to protect the price premium of such offers. Such IP rights allow competitors to provide a unique offering to customer and distinguish their products and services from those of competitors. Then regarding methods of valuation, different techniques are used when valuing IP assets. Though they usually share similar type of concepts and principles. These methods can be generally divided into two groups, qualitative and quantitative valuation method. In the context of qualitative valuation method, attempts to rate and score the IP based on factors such as the strength of the IP rights and their legal certainty. While quantitative valuation methods attempts to calculate the monetary value of IP, which includes three major approaches like the cost approaches, the income approaches, the market approaches, and each of these methods may present a number of variation whose applicability is also decided by the valuer based on the particular circumstances of the assets. Then based on the economic principle of substitution, which states that the investor will not be willing to pay a bigger price for an IP assets than the implied cost of acquiring, producing, or developing a similar IP assets capable to producing the same economic value. Within the cost approach, one may follow the historical cost method, which takes into consideration the accounting records of the owners of the IP to establish the actual cost of creating and developing the IP assets. The reproduction cost method, which looks to the total cost at current price of developing an exact replica of the IP assets. And the next one is the replacement cost method, where calculating of cost at current price of creating an assets which provide the same functionality or utility as the original IP assets, but which due to new technology, can actually go beyond the original IP rights. So it should be go beyond the original IP rights to replace the as per the replacement cost method. Since the cost approach tend to be relatively objective, fact-based, and consistent, it usually helps establish a floor on IP valuation. In this approach of IP valuation, the key inputs are the cost that will be incurred to create, protect, enhance production, and commercialize an IP assets. For example, say R&D cost, IP protection and maintenance cost, productization cost, then management cost, regulatory cost, etc. And other inputs of the cost approach may include the degree and rate of obsolescence of the IP assets, the useful life of the IP assets to calculate the amortization value, the cost of creating or buying an IP assets of similar functionality or utility to calculate the opportunity cost of the capital, etc. However, some disadvantages of these approach are say cost cannot be a cost can be actually is a poor indication of value, and this approach often implies that all costs and expenses related to the IP assets are creating value. This approach does not consider the income generating capacity of the IP assets. For example, if high costs are incurred to create an IP assets with low commercial potential, a buyer or licensee would be unwilling to rely on the cost approach or cost approach to calculate the value of the IP asset. Conversely, if the cost of creation is low and the true commercial potential of IP assets is high, then the seller or licensor would not want to rely on cost approach method of valuation of intellectual property assets. In case of income approach, the income approach of IP valuation is based on the premise that the value of a business or business assets originates from the income that the business or assets can generate for the investors. The value of a business assets equal the estimated earning the assets can produce over the productive life of the particular assets. And the reliability of income method depend on the reliability of the projection of futures earning in the form of cash flow or avoided cost, obviously. Again, the economic life determine economic life determination is particularly difficult for high technology IP, since it is directly impacted by further development cost, the replacement of a particular product, the cost of market entry, the lifespan of the related product, etc. And the final one is market approach. The market approach uses comparable transaction. It uses comparable transaction to measure the value of an IP right. The compared transaction should be for similar kind of IP right, that is the price paid for a purchase of similar IP right. For example, if we consider an example that royalty or say franchisee rate in a given market or sector can form a basis of discussion in negotiation around value. If the comparison transaction is not identical, then valuer need to be able to make adjustment for any material differences. Once comparables have been found, the valuer needs to consider the relatively market strength and legal strength of IP right and make adjustment for the significant differences between the comparison transaction and the IP right being evaluated. The main advantages of the market approach is that if a good comparable can be found, this can be a very quick, simple, and defensible way of determining market value. The main disadvantages, however, is that it is often difficult to find true comparison. IP rights being by nature heterogeneous or even unique in nature. Adjustment of inexact comparable add subjectivity to the valuation also. Regarding the accounting of IP, accounting actually plays a significant role in shaping thoughts, beliefs, meanings, and action of market participants. In the present context, IPR accounting is very much relevant as corporates around the world are awaking to the revenue generating potential of intellectual assets, and the issue of accounting for intellectual property gains importance day by day. Moreover, different accounting practices are prevalent nowadays, which resulting in differencing in balance sheet, profit and loss account, etc. Further, there is a absence of organized and transparent market and subjectivity involved in valuation. There are difficulties in determining value of IPR, etc. Moreover, accounting rules are evolving to enhance reporting or disclosure of IPR. And finally, to report the internally generated IPs, we need accounting of IPs. Moreover, IPR accounting is also important from the viewpoint of managerial and financial viewpoint. It increases transparency, shows how a firm manages its IP, reports current and future income from IP-related employees' contribution. Then reduce information. It reduce information asymmetry and enhance corporate reputation. And obviously, it acts as a marketing tools since it enhances reputation and adjusts stock prices. In the mid-80s, the Reckitt and Coleman, a US-based company, put a value on its balance sheet for the Airwick brand, the brand that it has brought. In 1988, Rank Hovis McDougall, a leading UK food conglomerate, paid heavily on the power of its IPs to successfully define a hostile takeover bid by Goodman Fielder Varieties. This was the first independent IP valuation, establishing that it was possible to value IPs not only when IP had been acquired, but also when they had been created by the company itself. And after successfully defining the bid, RHM included in its 1988 financial accounting the value of both the internally generated as well as the acquired IP under intangible assets on the balance sheet. Further, in 1989, the London Stock Exchange endorsed the concept of IP valuation as used by RHM by allowing the inclusion of intangible assets. This provided to be the driver for a wave of major companies having good IP to recognize the value of IPs as intangible assets on their balance sheet. Accounting has so far developed as very scarce vocabulary and syntax to communicate the value of IP to investors and managers. In accounting, the financial position of a company is phrased in terms of profit or losses, assets or liabilities. Among these variations, the combination that accounting currently allows to phrase IP are rather unsatisfactory, and even the internationally most widely accepted standard, the US GAAP and the International Financial Reporting Standard IFRS, formerly called as IAS, are not well equipped to deal with IP. As per the US GAAP, according to the Accounting Principle Board, APB 17, a company should record cost of intangible assets acquired from others. So they only keep record of the intangible assets which they acquired from others, including goodwill as an assets also, and all cost incurred to develop intangible assets that are not specifically identifiable should be recorded as expenses. Whereas intangible assets has been recorded, its cost should be amortized by systematic charges or charges to income over the estimated period of benefits of the assets. The amortization period should not exceed 40 years in each case. In any case, it should not exceed 40 years as per the US GAAP. And as per the International Accounting Standard, IAS 38, and intellectual and intangible assets is recognized in the recognized on the balance sheet if the asset cost can be reliably measured and all future economic benefits, especially attributable to the assets, will flow to the enterprise. All other costs incurred are non-monetary for non-monetary intangible items should treated as expenses. The intangible assets is reported in the balance sheet at its cost less any accumulated amortization value. So in a nutshell, we can say that we can say that internally generated IP is treated as an immediate expenses. The same applies to research and development related to creation of IP. This means that the balance sheet offers distorted information on how IP is made. The cost incurred for the creation of IP are reported at one single point of time, while the IP is accounted for only for the context of commercial transaction. Unlike internally generated IP, acquired IP is reflected on the balance sheet. For this IP is valued at its acquisition cost and amortization over a period of its useful life. However, this may lead a serious confusion, whereas internally generated IP is considered to be worth nothing. The IP that change hands may be worth hundreds of millions of dollars. Thus, a company which decides to sell or license internally generated IP, which appears to create profit virtually out of nothing, as the IP that generated these profit does not appear in the balance sheet. So to outsiders, it might be looks like a magic. In the we may conclude that we may conclude by saying that in this context, in the era where the where the economies are mostly driven by knowledge, any business entities, be it big or small, will have to rely on intangible assets for its survival and growth. It is essential to note that from an innovative idea to an invention, at every stage of the chain, IP enhances the value of the company. But unawareness among the youth, academicians, researchers, industrialists, and traders in India about IPR, its valuation, accounting, and its benefit is the main reason for lagging behind in IPR participation. Even micro, small, and medium enterprises, which is called as MSME, that constitute around 95% of say all units and 40% of total value addition, nearly 80% of employment of the total manufacturing sector, and 35% of total export are also lacking in IPR age. Due to aforesaid reason, there are no Indian multinational company in top 100 patents applicants worldwide. And despite its importance in modern business, accounting for intangibles, in particular IP, remains a challenge for both preparators and users alike. Thus, there is a huge need to develop appropriate guideline to realize IP strategy, uniformity of IPR valuation and accounting process. Definitely, India has the potential and skill to emerge as global leader if appropriate IPR strategy is practiced to improve the share in its global trade. Further, it is essential for the policymakers to include IPR in basic educational system and promote IPR registration by encouraging the encouraging the innovators or creators. India is having all the resources in terms of say available of raw material, cheap labor, innovative and creative dedicated manpower, etc. So it is high time to understand the real value of our intangible assets and protect these assets from being infringed legally to build up intellectual capital of the company or the organization. No doubt that India and other developing countries will definitely improve its proportionate share in global trade by exploration of intellectual property right in the coming days. Thank you for patience hearing. I also express my sincere thanks to the organizers of the webinar for inviting me to share my views on IPR and its valuation and accounting. That's all.
Thank you, sir, for such an enlightenment and thought-provoking lecture. Sir, during your speech, a lot of questions was put up by the participants. I have selected some of the questions for this question and answer session.
Yes, sir.
The first question is from Ashok Kumar Tripathi. He had asked 3 questions. The first question is, can internally generated IP by an organization be shown in the balance sheet? What are the provisions in this regard in our accounting standard? This is
as per the IFRS 38, there is no specific provision for show the intellectual property assets in the balance sheet if it is generated internally. If they can segregate the cost of developing the IP separately, then they can show the particular value in the balance sheet, and they need to amortize that particular amount systematically through the useful life of that assets.
So the second question was put up by him only. The question is, how does government encourages protection of IPs to MSME in India?
How the
MSME in India. How does the government encourages protection of intellectual properties to MSME in India?
Yes, they need to aware the registration of different form of, say, intellectual property right, say by patent, copyright, trademark, etc. And the government should make different awareness program to develop or to take registration for the different type of say intellectual property, and if the MSME industry take registration of their innovation, like in the form of, say, patent, copyright, trademark, etc., then they will protect their innovation.
Okay, sir. The third question is, goodwill being an intangible asset, can it be sold separately like IPs?
Sir, pardon?
Goodwill being an intangible asset, can it be sold separately like IP? The question is this.
Yes, but goodwill can be sold independently, but actually no accounting standard till now specifies the accounting aspects of intellectual property right. Only the IFRS 38, they deal with the valuation. They deal with the accounting of intangible intangible assets, and under the intangible assets, goodwill is one kind of intangible assets, and when we purchase goodwill from another company, we can show the value of goodwill in our balance sheet also.
Okay. So this is the question from Dr. Anup Kumar Raut. He had asked, how do you value geographical indication? How do we value geographical indication, GI?
No, I didn't have any idea regarding the valuation of separately for the geographical indication.
Okay. I would like to say, if any participant want to ask any question to Dr. Taruknath Sahu, they can unmute themselves and ask.
Actually, geographical indication is a part of, as it is a part of intellectual property right. as per my discussion, I covered the whole things of intellectual property right valuation. It may be of geographical indication, or it may be of patent, it may be of copyright, etc.
Okay, do any participant want to ask anything? Any question? Okay, thank you, Taraknath Sahu, sir. It's over to Santanus Malik now.
Thank you.
Okay, thank you, Arif sir. So it's a very informative session from that we have heard from Taraknath Sahu. Now I would like to invite the next speaker, Dr. Prem Kumar Agarwal. Dr. Prem Kumar Agarwal. He is an alumni of St. Xavier School and College. He pursued his LLB, LLM, and PhD from the University of Bardhaman, West Bengal. He was a former judge under the jurisdiction of Honorable Calcutta High Court and founder faculty of West Bengal National University of Juridical Science, Kolkata. Dr. Agarwal is presently serving as the head of the department of the law section in the Hooghly Mohsin College. As a PhD guide, he has guided several research scholars under his supervision, and already 9 scholars has awarded with their PhD degrees. A strong advocate of human rights, civil liberties, he visited Sweden as a cultural ambassador and delivered a series of lectures on culture, polity, and legal system of India under the prestigious group study exchange program of Rotary International. A past district Rotaract representative, Dr. Agarwal, has addressed various youth convention in Singapore, London, Paris, besides many places in India. Dr. Agarwal is a PDRCC, and apart from these, he has published different lots of journals in different journal books, and involved in different academic activities and in jurisdictional activities. And he is a passionate about preparing his students for career in judicial service, legal service, prosecution service, etc. So now I would like to, sir, please enrich us with your knowledge. And now the floor is yours, sir. Please continue. Thank you, sir.
Good afternoon. Am I audible?
Absolutely, sir.
Okay.
Yes.
Thank you for the generous introduction. At the outset, I am extremely thankful to BV College for inviting me in this webinar and giving him the opportunity to learn from erudite scholars. Professor Sorkhel, Professor Gupta, Professor Das, my dear Omolindu, these are the people I can recollect, I know. It's really a very important day for me, so that I could listen to such erudite deliberations from Professor Sahu, who just spoke before me. And I am really, it's heartening to learn and see that much of the intellectual property right information has already been delivered by the earlier speakers. As Professor Sorkhel very nicely delineated the outlines of the intellectual property rights, Professor Sahu also delved quite deep into the subject. Now, I will try to give some food for thought from the layman's point of view rather than from the technical law point of view. So, intellectual property rights. Intellectual property rights has the term property in it. So, before going into intellectual property, let us try and understand what is property. Professor Sorkhel was trying to distinguish between property rights and property when he spoke. It's always very joy to listen to Professor Sorkhel. So, right and property. Now, in our jurisprudence, we have Salmond who tried to define property. Property is defined for students of jurisprudence and law as a bundle of rights. Bundle of rights. So, if I tell you that I gift you a farmhouse, but you have no right to reside in it, you have no right to sell it out, you have no right to lease it out, you have no right to mortgage it out, does the brick and mortar have any value for you? So the property is the compendium of the rights associated with the resource. So Salmond defines property as a bundle of rights. But when in a training session for the IS officers, I have shared it various times, when I was explaining them the concept of property, one young IS officer, he came up and said, "Sir, I have a question." So I said, "Yes, what is your question?" His question was, he said, "Sir, so you are saying the rights are the property, then the resource doesn't have any value. Say I am hungry and I have Kolkata's Rasgulla in my hand. The material is important because that will satisfy my hunger." So that question gave me a few sleepless nights, and I reformulated the definition of property by adding something to it in the definition of property. Property is a bundle of rights exercisable over a resource capable of satisfying human wants. Now, the resource over which the rights are recognized or exercised, if that resource is tangible, the property itself is tangible. But the resource, if it is intangible, the property is intangible. The rights are always intangible. So, intangible properties are those properties where the resource over the rights are exercised are themselves intangibles. Like, say, if I obtain a patent on an invention, the invention is intangible. If I obtain a copyright for some creative work, the creativity itself is intangible. That's why they are intangible properties. Now, my next food for thought will be, why have intellectual property rights become so important? How can I change these slides?
Sir, you just click the different slides one by one, it will change.
Yes, I'm clicking, it's not changing.
I would advise you to again go for presentation. You close it and then again open.
Okay.
Oh.
Yes, sir.
Okay.
And share the entire screen.
Oh, share the entire screen.
Yes.
Sir, we have
Yes.
your presentation with us. So if you face any technical problem, we can present it on your behalf.
Yes, please do that. That would be
Okay,
better.
thank you, sir. Then I request Arnab Babu or Arif to present the screen. Arif, can you hear me?
I have the presentation. Should I present?
Yes, you present better. I have already shared the presentation.
So I can share it.
Okay.
Yes. Next slide.
Okay, sir.
Yes. So intellectual property rights, why has it come to the forefront in the last 2 decades? What is so unique about intellectual property rights? So if you turn the pages of economic history of the world, if you try to delve on the portfolio of the persons who are the wealthiest persons on the face of the globe now, say Bill Gates or others, you will find their portfolio consists of intellectual property rights. About 2 decades back, it was the Sultan of Brunei, and his portfolio contained only tangible assets. So what is that magic in intellectual property right which can make you rich at a so fast a pace, that is leverage your income? Now let me try and explain this with the help of a linear equation. Now when I take the help of the equation, I don't claim myself to be an expert in economics or accounting, because we have luminaries from the fields of economics and accounting around me. It's just a layman's approach. Income is equal to time into rate. I is equal to T into R. So if you want to move I to the power n, you'll have to either move T to the power n or R to the power n. In intellectual property, what we do is we move T to the power n. How? Say somebody has invented some, say, life-saving drug, say some molecule, and if he wants to keep it as a trade secret or is at confidential information, and say charge an exorbitant price for that, how much can he produce by himself and for how long? Instead of that, if that is licensed as a patent, then he gets enriched at the costs of others' entrepreneurship. That is the magic of intellectual property right, leveraging income. So if you want to become infinitely rich, that is, if you want to move I to the power n, you move T to the power n. So if all medicine manufacturers who have bought the patent right from you, whatever they earn, you get a slice of that, and that makes you infinitely rich. Another very favorite example which I introduce to the students of intellectual property rights is, say a sultan in the Middle East owns an oil well, and an engineer who is expert in the field of oil exploration has the knowledge how to excavate that oil. Now, whose wealth is important and why? Now, the answer is both are important, because without the knowledge, what will you do with the oil? And without the oil, you cannot do anything with the knowledge. But then in the long run, the person having the knowledge will earn more than the person having the oil well, because oil one day will finish, but the knowledge can always be licensed and you can earn royalty on that. And this is the age of knowledge economy, not the brick and mortar economy. And therefore, intellectual property rights have occupied center stage. And so much talk about intellectual property rights all over the world is going on, especially after TRIPS, which tries to regulate through WTO the intellectual property right transactions. Next slide, please. Now, bird's eye view of intellectual property right, Professor Sorkhel has already dwelt on this. But then intellect as distinguished from manual labor is the source of intellectual property. It's more of skill and art which is behind the intellectual property. Now, property definition as highest right a man can have to anything being that right which one has to lands or tenements, which does not depend on others, is in the R.C. Cooper's case, Supreme Court gave this definition. Thus, intellectual property is that property where the right of ownership accrues from one's own creation using his intellect. Although it's an intangible property, it needs transformation into a tangible form for protection. Sir already said this, that it must manifest in some material form. Ideas cannot be protected. It must manifest in some form. Either in the form of invention, it must manifest in some invention, or creativity must manifest in some, say, paper or some other form, or some other manifest form. Yes, next slide, please. All intellectual property laws are national in nature. Yeah, this one must understand. Although we have several multilateral treaties like patent cooperation treaties, WTO TRIPS itself is a multilateral treaty. But then, if you register patent in India, it is valid in India. It is not valid in the other countries which are signatory to the patent cooperation treaty, or for that matter, other intellectual property rights. An exclusive right is granted for a certain specific period of time. Purpose of intellectual property, that is the jurisprudential rationale of intellectual property, rewarding the creator, that is the individual interest, and taking care of social interest. Let me explain this a little bit. We all know monopoly is bad, or monopoly is discouraged in economics. But then in intellectual property, what we allow by law is a monopoly. Say one is a patent holder. He is allowed to monopolistically exploit his patent for 20 years. Now, what is the rationale behind this? Why this sort of monopoly is allowed? Now, this is a symbiotic relationship between the inventor and the society. In patent, I'm taking the example of patent. In patent, the inventor shares his knowledge with the society through the controller of patents or through the registrar of patents. And as a trade-off, as a consideration, his monopoly to exploit the fruit of his creation is ensured by the state. So by doing that, we are rewarding the creator, we are rewarding the inventor. So that is incentivization of the inventor. If we do not reward the creator or the inventor, why should he work? But then, as a trade-off, as a consideration, he shares his knowledge with the society, which comes into the public domain after 20 years. So it is a very nice form of knowledge management. Let me give you an example. India had been a country which has been a repository of traditional knowledge for thousands of years. We know we had skills of healing terminal diseases in the form of by using herbs and other techniques. But then, since we did not have a proper knowledge management system, these wise people died with their knowledge. We did not have institutionalization or preservation of the knowledge. Now, intellectual property right allows or ensures such knowledge management. And in a knowledge economy, this is very important. That's why the jurisprudential rationale or the purpose of intellectual property is twofold. It is incentivization or rewarding the creator, that is his individual interest, and also taking care of the social interest. The knowledge comes into the public domain. Yes, next slide, please. Now, the jurisprudential rationale of Ipr: to reward effort and recognize creative contribution, to create intellectual wealth, to identify, protect, and exploit potentially valuable creative work, to create a better understanding of the various legal rights for protecting creative efforts, to increase the involvement of human resources in research and induce them towards being more and more creative. That is incentivization. Next. to ensure that interests, rights, and responsibilities of all involved are fairly determined, to allow for various forms of commercial exploitation of intellectual property. And finally, the most important, to ensure knowledge management in a knowledge economy. We are now a knowledge economy. We are no more a brick and mortar economy. Yes, next. Now, significance of IP standing in the era of commercialization. Once you appropriate your intellect in right way, nobody can snatch it from you. It's your property only. That's because, see, material wealth can be taken away from you by force, but then intellectual wealth cannot be taken away. Protection of intellectual property can provide you ownership, monopoly, exclusive rights, revenue, trustworthiness, better negotiation, collaboration. The most magical part is, even if you draw out for a while, your existence will not. So if you have created something which is intellectual property, you may go and rest, but your income will steadily come on, will come in, will keep on coming in. Yes, next please, next slide. Now, the various forms of intellectual property, all have discussed, but then just let me repeat it. Patent, copyright, trademark, trade secret, design, geographical indication, plant variety protection, traditional knowledge, semiconductor integrated circuits, and layout designs. Yes, next. Now, patent. Now, what is the etymology of the word patent? From where does the word patent come? The etymology of the word patent is pateni, and pateni means open. So when you disclose your know-how, you make it open. That is where from the word patent has come. So patent, first to file. Patent is an exclusive right granted to the inventor for a period of 20 years to exclude others from any kind of usage. In India, patent is governed under the Patent Acts and Patent Rules 2003. Patent is granted to the inventor who has invented something new, useful, which was not in existence prior to the invention. Now, here we have to distinguish between invention and discovery. Discovery is something which was there, you found it out. But invention is creating something new. Say, Newton's laws of force, they are all discoveries. Even Einstein's E is equal to mc square is a discovery. But invention, Thomas Alva Edison has invented the bulb. So invention means a new product or process involving an inventive step and capable of industrial application. This concept of inventive step was inserted in our definition of invention in section 2J of the Patent Act by an amendment in tune with the WTO. Patent establishes a contractual relationship between the patent holder and the society at large, not in between the patent holder and the registrar. So it is a contract. Now, most of us are from the commerce background, and all of us are well conversant with the Indian Contract Act 1872. Contract is an agreement enforceable by law, and we all know that a contract is not possible without a consideration. No consideration, no contract. But then, when we say patent is a contract, where is the consideration in that contract? Consideration as defined in section 2D of the Indian Contract Act as when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing, such act, abstinence or promise is the consideration for the promise. These are all elementary lessons in contract law. But then, which is the consideration in the contract of patent? When the inventor discloses the know-how, how he has created in the form of specification. This is a technical word, a provisional specification or a complete specification. That is the consideration which flows from the inventor to the society through the controller of patents or the registrar of patents. Whereas the promise of the state to ensure monopoly of exploiting commercially the fruit of his creation is the consideration which flows from the state to the inventor. And therefore, it is a perfect contract, and it is a contractual relationship which exists between the inventor and the society through the registrar. Yes, next. Essential elements of patent. Professor Sahu also just mentioned this: novelty, non-obviousness, and usefulness. Novelty means it must be new. Before the date of filing of patent, the subject matter has not fallen in public domain. It must be new. It must be non-obvious. Now, non-obvious to whom? Non-obvious to a person who is well versed in that field of knowledge. The invention which claims patent must be a non-obvious knowledge to a person skilled in that art. It must be useful, that is, it must have utility. These are the three classic requirements of patentability. It must be novel, that is, it must be new. It must be non-obvious. To whom? Not to a layman, to a person who is skilled in that particular field of the art. And it must be useful. Let me share a very interesting case law decided by the Supreme Court on the question of non-obviousness. Now, there was this company who was manufacturing air coolers. Now, this company was claiming patent on an invention which was at first rejected by the controller of patents. Now, what was the invention? The invention, it may appear very obvious to a layman. When I'll tell you the secret of the invention, you say, what is so unique about it? What is so non-obvious about it? Now, they already had an air cooler in the market. Now, they were claiming that in this new form of air cooler, they have introduced, they have used a technology which is non-obvious, and it prevents certain kinds of bacteria and microbes from entering into the room. And what was the technology used? They have reduced the size of the hole in the sheath which filters the air when the air is filtered through the air cooler. They have just reduced the size of the holes. Say it was 50 microns, they have made it 10 microns. So the controller said, what is so unique about it? It is very obvious. But then it was decided by the court that although it may appear to be obvious as such, but the way in which it was applied in this particular gazette, in this particular invention, it is non-obvious for a person skilled in that art, because it has immense utility ultimately, and therefore it qualified to be patentable for the invention qualified to be patentable. This is one example which came to my mind and I shared it with you. So non-obviousness and usefulness has to be considered, has to be assessed on the basis of the context of subject matter of the context. Next. Now this filing of patent. So one who claims to be an inventor, he may apply for a patent. A person who is the legal heir of the patent, if the inventor has died, he may apply for patent. Or any other person whom the inventor has authorized may apply for a patent. Now, in order to apply for a patent, the application must accompany what is technically known as a specification. Now, what is a specification? Specification is the technical term which is used to connote or denote the laying down of the details of the invention. And what will be the standard of these details? That a person skilled in that art must be able to work out that in practice. So if you claim to have created some or invented some machine, some mechanical device, a mechanical engineer must be able to work out that invention with the help of your specification. Or if you have invented something, say in the automobile, an ordinary automobile engineer must be able to work it out. Say you are submitting your provisional or complete specification and you write it in Hebrew or in a language which cannot be understood by anyone. That is not allowed. The complete specification or the provisional specification, as the case may be, must be written in a language which can be understood by a person ordinarily skilled in that art. Now, publication of patent application. This patent application will be made public 18 months from filing date of patent application. Now, why does it require publication? Because there may be persons who already have that knowledge, or it must be maybe in a public domain. So unless it is publicized, unless it is made public, how can one challenge that? And how can one ensure that it is novel? Then is the request for examination to be applied within 48 months from the filing or the priority date of patent application. And mind you, this has to be filed with the controller of patents, whose headquarters is in Kolkata. This is some solace for us, people of Bengal, that is, there is some office whose headquarters is in Kolkata. So request for examination has to be made within 48 months from filing or priority date of patent application. Then we have examination of patent. The patent will be examined by the controller or the team. Then we have the FER, that is, first examination report will be launched. Then the response to the FER must be submitted within 6 months, which can be extended up to 3 months. On that, there may be a hearing, and if it is found to be already existing, it may be refused. If it is refused, the inventor or the claimant can appeal to the appellate board. If it is granted, then you are a patentee, and renewal fee to be paid until 20 years because you are entitled to use it for 20 years. Let me clear something very important here as a law person. Grant of patent is never final. It is always said among students of law. Why? It is always open to challenge. I draw the analogy of this with the prescriptive right in law. If you claim a prescriptive right to easement, it is mentioned in the Limitation Act that if you have enjoyed a right of easement for 20 years of any right of way, right of waterway, right of sunshine or air, then you are entitled to it as a matter of right. That is called prescriptive right. But then it remains in an inchoate form unless declared by a court of competent jurisdiction. It must be brought before a court of competent jurisdiction within 2 years next of the 20 years of usage. Something like this is there also in patent law. You may be granted patent, but it may be challenged at any point of time. And unless a court of competent jurisdiction, after due trial, clears the objection, your patent is not final. This is one concept which is required to be elaborated upon for the non-law persons. Next slide, please. Now, how do you transfer rights? If we call it property, then it must be allowed to be appropriated by transfer. Transfer of the rights of a patentee can be by operation of law, by assignment, by license, by compulsory license. Now, operation of law, the best example is if the patentee dies, then just like other properties, it is inherited by his heirs. Assignment is legal, equitable mortgage. So it is just transfer of the right. That is, the patentee may transfer it for royalty. License, it may be express, implied, statutory, exclusive, non-exclusive. Now, what is compulsory license? Compulsory license is patent being a property like other property. There can always be an acquisition and requisition of property Just like your tangible property, the government has an eminent domain right of acquisition and requisition of private property for public purpose. It is a constitutional right of the government, of the state. The same is also applicable for patent, since it is another property. So let me give you an example. Say somebody has a patent for a medicine, which is a life-saving drug, say. And say in the time of COVID, say some pharmaceutical company is the patentee of a particular drug, which is in high demand, but that particular company is not manufacturing the drug to the extent required. Then for public welfare, the state may grant compulsory license to manufacture that drug to other manufacturers. That is also provided in the Patent Act. Yes, next slide, please. Now, opposition to the grant of patent. Pre-grant opposition, before the patent is granted. Post-grant opposition, as I already told you, after the patent is granted, you may oppose, the matter will go to the court, and the court finally decides whether the patent is right or not. Surrender of patents. At the instance of patentee or any person interested may claim for surrender to the controller. Revocation may be done by a petition by any person interested or central government or counterclaim in infringement suit, subject to certain conditions. Yes, next. So that is the almost little thought, food for thought for patent. Now let us come to copyright. Now what is the etymology of the word copyright? Right to copying is the etymology of the word copyright. Now you have a right to copy and commercially exploit a work which is your own, which is creative. So if you have a right to copy and commercially exploit your creative work, you have a copyright in it. Now, the term copyright is also attributed to Designs Act. There also, the intellectual property which is protected by the Designs Act is called copyright. That copyright is in design. So copyright, this right prohibits someone to copy another's original work. It's a negative right and confers a bundle of rights to the owner of the original work. It is a statutory right. Work protected under statutory rights are original literary, dramatic, musical, and artistic work, cinematograph films, and sound recordings. Now, unlike patent, in copyright, registration is not mandatory. We all are in the field of academics, and copyright is, I think, the most relevant intellectual property right for us. In copyright, you need not register. The moment you write a book and publish it, you have a copyright in it. And you are protected by all the protections mentioned in the Copyright Act. But then, in order to be protected by the Copyright Act, your work must be original. If you copy from somewhere else, you are not entitled to copyright. Yes, next slide, please. Now, rights covered for protection. Economic rights. Economic rights, you can exploit commercially by reproduction of your creative work. Right of public communication by receiver. Right of public display. Right of public exhibition. Right of public performance. Right of public recitation. Right of transfer of ownership. Public rental. Public lending. Public distribution. Exploitation and any other kind of exploitation. Now, there are certain neighboring rights. Now, this copyright is available, as sir already told, author's age plus 60 years. And sir said about performance rights and broadcaster's rights also, that is, the period for performance right is 25 and broadcaster right is 50 years. Now, what is performance rights? This is very important right which is coming up, especially for quality teachers, I'm telling you. because the coaching centers these days are multi-million-dollar industries. Say Professor Sorkhel is teaching economics. You know, he's a well-known, very eminent teacher of economics, and students, you know, have an appetite for his way of teaching. Say his video is recorded by some coaching center, and that coaching center is playing the video in various, you know, centers or their branches in India. Now, sir can claim a portion of the profits earned by that coaching center through these performance rights. Let me give you another example. Movers and Shakers was a program in the television where the Shekhar Suman used to imitate Lalu Yadav. And people during that program, the viewership was very high. So the TRP of the television channel was very high. So television channel was earning from that program. But Shekhar Suman was imitating Lalu Yadav. So the performance rights can be claimed by Lalu. A royalty from that income can be claimed by Lalu under the performance rights. But this right in India is at a very nascent stage. We need to concretize the jurisprudence behind performance rights. Broadcasters' rights, we had various cases in the Supreme Court, especially the Zee Telefilms case versus the BCCI on telecasting rights or broadcasting right of cricket matches. Now, moral rights, right of publication, right of paternity, right of integrity. Now, what are these moral rights? 60 years is the time period after the death of the author. The heirs of the author can claim monopoly over copyright. But then, commercially, one can exploit after 60 years of the death of the author. Say, Vishwabharati had the copyright of Rabindranath Tagore's writing up to 60 years after the death of Rabindranath Tagore. After that, we find that Sanchoita being sold even in the railway compartments. But that doesn't mean you have a right to change Rabindranath Tagore's poems and publish them in the name of Tagore. তাহলে নীল নব ঘন আষাঢ় গগনে তিল ঠাইয়া নাহিরে এই লাইনটিকে আমি চেঞ্জ করে নীল নব ঘন আকাশ গগনে তিল ঠাই আর নাহিরে এই লাইনটাকে চেঞ্জ করে আমি অন্য কোনো লাইন লিখে রবীন্দ্রনাথের নামে পাবলিশ করতে পারি না। Many such things are happening in Bangladesh. It is said that novels, Bengali novels written by Buddhadev Babu is being published in the name of some other author. There, your moral rights of the author is violated. You cannot change anything in the writing of the author. That right is eternal. It cannot be changed. That is right of paternity and right of integrity. These are moral rights. They cannot be taken away from the author by any means. Yes, next slide, please. So, originality in expression, novelty versus originality, idea versus expression. Now, the biggest problem in intellectual property is we would, if we could, protect ideas. Say Omolendu and me are having a chit chat, and I discuss with Omolendu a plot on which I am about to make a cinema. I am a film director. Now, Omolendu had always been a smart fellow. Now, after listening to my idea, he comes out with the film before I come out with the film. Now, do I have any remedy against Omolendu in law? We would if we could protect the idea, but we cannot unless it is manifested in some material form. So in copyright, we can only protect unless we can only protect in the material form and not in the form of idea. This is known as the sweat brow doctrine, that is merely an effort or idea. Rejected sweat brow doctrine both in US and India because minimum content of originality must be there, and all those things were discussed in the Eastern Book Company versus D.V. Modok. I don't want to go into the technicalities. But this idea thing is a very, very important expression. Now, let me here delve a little into plagiarism versus copyright violation. I think it will be of some interest for the academicians. One of my acquaintances or one of my friends, professor, he went to the University of Melbourne, and there he was confronted with a very unique situation. He was invited by the plagiarism committee for helping them out in a particular fix. What was the fix? A student of Bangladesh origin was reported against by an examiner who was examining his script. Now, what was her problem? She had written an answer exactly ditto from a book, 15 pages. Now, when she was asked to explain, she said that I have learnt it by heart and then written it by myself. I did not do any unfair means. Now, this Indian professor was asked to help just to elucidate, is it a normal practice in countries like India and Bangladesh that students learn by heart and reproduce them in the answer scripts? Now, that friend of mine had to say, yes, this is a common practice. But then, according to the Melbourne University standards, it is a plagiarism. You cannot reproduce even by learning by heart, because these sentences are not your original without acknowledging the source. So this was one example of plagiarism. I could not withstand the temptation of sharing it with the academicians. So plagiarism and copyright violation are a little different. In copyright violation, there must be a commercial exploitation. But in plagiarism, it is intellectual dishonesty. Is that clear? So next slide, please. Period of protection. In case of original literary, dramatic, musical, and artistic works, author's lifetime plus 60 years. Cinematographic films, 60 years from the beginning of the calendar year, next following the year in which the film is published. In sound recording, 60 years from the beginning of the calendar year, next following the year in which sound recording is published. Yes, next. Now, ownership and transfer of the rights in copyright. The author is the first owner of the concerned work, except certain circumstances like owner and author may be different. Like, say, an editor who is employed by some newspaper, his editorial's copyright is owned by the newspaper and not the editor. But then, generally, the author is the first owner of the copyright. So, transfer of interest can be assignment, can be license. It may be voluntary, it may be compulsory, it may be statutory. Yes, next. Now, infringement. Infringement means violation. So, unauthorized use of exclusive rights. Any kind of dishonest profit accrues by manifestation of those exclusive rights. Sale, hire without authorization. Imports by infringing copies of the work. Exceptions. Now, this is one section of the Copyright Act which all academicians must know well, and that is section 52 of the Copyright Act. Fair use doctrine. Up to what extent can you use the work of another without incurring the wrath of the Copyright Act, without being caught by the Copyright Act? That is laid down in the fair use doctrine principle under section 52 of the Copyright Act. Yes, next. So before going to trademark, let me share another very important anecdote regarding copyright versus patent. We are living in the cyber age now. Patent ensures monopoly protection for 20 years. Copyright ensures monopoly protection for author's age plus 60 years. So a very long length of time. But the IT industry, which is primarily allowed to protect its creativity in softwares by copyright, that is for author's age plus 60 years, is demanding patent protection. Both the NASDAQ, that is the American IT industry, as well as the Indian IT industry. Are they fools? They already enjoy a protection for author's age plus 60 years. But they are asking it for 20 years. Why? Copyright is a very soft law. You can escape the Copyright Act by cosmetic changes. And IT industry is an industry which requires a stronger protection for a shorter length of time because it is always changing very fast. And hence, they are demanding patent protection. And now some softwares which has hardware component, we have patent protection also. Yes. Now, so trademark. Trademark, we all know, is a mark, other speakers have already spoken, which distinguishes the good or the service from its peers. So a trademark means a mark capable of being represented graphically, which is capable of distinguishing goods or services of one person from those of others. Like Tata's pipe, by the way in which the word Tata is written from other pipes, or Cadbury, other trademarks. May include shape of goods, their packaging and combination of colors. In India, trademark is governed under the Trademarks Act 1999. All marks are not trademarks. Yes, please, next slide. Trademark identifies the sources of the product. Thus, it is directly linked with the goodwill and the quality of the product. For registered marks, statutory remedy will be available. However, even if a trademark is not registered, some sort of a remedy is available under common law as a remedy for passing off. We'll come to that. Essential elements of a valid trademark. Capable of being represented graphically, it must be distinct. Distinctiveness is another characteristic. Confusion arising from similarity, not from dissimilarity. Distinctiveness helps customer not to confuse. So there must not be any sort of, there must not be any deceptive similarity between two trademarks so that customers or consumers are confused. I'll give examples. Yes, next slide, please. Period of protection is for 10 years, can be renewed repeatedly. Thus, protection is for perpetuity if renewed every 10 years. Transfer of interest, rights or interest can be assigned or transmitted with or without goodwill. In both cases, registered or unregistered, subject to certain statutory limitations. Now, let me give an example of deceptive similarity. Trademark, as I told you, distinguishes the goods or the service from its peers. So the goodwill of a product is, the trademark speaks volumes about the goodwill of a product. Now, there was this very interesting case. There is a company known as Seat Tires, and Seat Tires brand is a very popular brand. In the Seat Tires, in the trademark, you have the picture of a rhino, if you remember. Now, the Seat Tires owners, they found that their market in the southern part of India is gradually plummeting, is going low. Why? They investigated and found that another tire is being marketed in the southern part of India, which is Rhino tires. The name is Rhino tires. The picture of Rhino is not there. But in Seat tires in the trademark, the picture of Rhino is there. So whenever a consumer or a customer is going to purchase Seat tires, he is buying Rhino tires thinking that he is buying Seat tires. So there was a deceptive similarity. The matter went up to the Supreme Court, and the Supreme Court ultimately decided and asked Rhino tires to change its name. Although apparently there was no similarity. Seat tires did not have the name Rhino, and Rhino tires did not have the picture of a rhino. But then it was confusing for the customers. So it was considered to be a deceptive similarity. And therefore, Rhino tires was asked to change its name, and now it is marketed in the name of Ramkish tires in southern part of India, especially in Tamil Nadu. Yes, next. So trademark can be of service, goods, ordinary, and well-known. Now goods, it can be collective or certification mark. Yes, next. Infringement and passing off. So if the mark is registered, you have statutory remedy under section 30 of the Trademarks Act 1999. But if the trademark is unregistered, how is the protection available? That is very interesting. Now, these favorite examples of mine, which might have been heard by many of you before, but I cannot withstand the temptation of sharing it with you once more. This poor fellow Dulal, whose Talmichri or palm candy is a household name in Bengal. Say Dulal had been manufacturing this palm candy from his village home, say for the last 5 decades. Now, Dulal is a poor fellow, illiterate person who doesn't know of these, Trademarks Act or Intellectual Property Right. But then his brand commands a lot of market, and therefore his monopoly of Dulale Talmichri, I'm just giving an example, this is not a real fact, is say a household name in Bengal, and people just buy Dulale Talmichri thinking it to be of very good quality. Say one fake Dulal from somewhere else starts manufacturing palm candy in the name of Dulale Talmichri. Now this poor fellow Dulal goes to the court. The court says, have you registered your Dulale Talmichri as a trademark? If he says no, should he be deprived of his remedy by stopping the fake Dulal from manufacturing the palm candy? And if this fake Dulal is allowed to continue marketing the Talmichri or the palm candy in the name of original Dulal, it is inequitable. It is inequity. The fake Dulal is getting enriched at the cost of original Dulal. Should the law not have a remedy for this? In law, we have a remedy which is known as common law remedy for passing off. The fake Dulal cannot be allowed to be enriched at the cost of the original industrious Dulal, notwithstanding that he has not registered his trademark. But then it must be bona fide. The classical trinity of passing off. These are the preconditions which must be proved before the court of law. In my example, by the original Dulal, goodwill, misrepresentation, and damage. If these 3 things can be proved by the original Dulal, he is entitled to the remedy of passing off, notwithstanding his brand is not registered under the Trademarks Act. Next slide, please. Now, trade secret or confidential information. Sir has dwelt on this, but then the most favorite form of confidential information is the recipe of any dish. As Sir said, the trade secret of Coca-Cola, the KFC, they have been preserved as confidential information. In India, we hardly have any law, but in US, there is a law known as Economic Espionage Act of 1996, which is represented as 18 United States Code. And this law protects the confidential information in US. In India, we hardly have any such law. The only remedy is under the Contract Act or under the IPC. Yes, next slide. Under trade secret, formula, pattern, physical device, idea, process can be protected. It depends upon the uniqueness of protected material. No registration, no such prescribed limit or period of protection. It can be under cover for perpetuity if the confidentiality and secrecy is maintained. The most important thing to be noted, there is no particular law with respect to trade secret in India, but has remedy under Contract Act and IPC. Injunctions may be granted. Yes, next. Now, design. Now, what is design? The intellectual property protected under the Design Act is also called copyright. So don't be confused with the copyright under the Copyright Act and copyright under the Design Act. I told you the etymology of the word copyright. Copyright is right to copy something original. So what is design? Design is the sum total of the shape, configuration, pattern, ornament, composition, color combination, contours, which has an appeal to the eye, the aesthetic appeal. To the model of a car, the model of a handset of a mobile phone. You all are quite acquainted with the legal battle between Samsung and iPhone over a particular model that was under the Design Act. See, this parachute coconut oil bottle, the particular design, the color combination, the contours, the sum total of this whole thing, which has an aesthetic appeal to the eye, is the design. In India, protection of design is granted to the Design Act 2000. In the name of design, the features, shape, configure, as I already told you, it may be two-dimensional or three-dimensional in both forms, applied to any article by industrial process or means. Article should be eye appealing. As I told you, it must appeal to the aesthetic sense. বাংলায় যেটাকে নান্দনিক পদ, সেই aesthetic sense, it must appeal to the aesthetic sense. Yes, next please. It does not include any mode or principle of construction or anything which is in substance a mere mechanical device. Any trademark or property mark as defined in section 479 of Indian Penal Code, artistic word as defined in section 2C of the Copyright Act. These do not come under design. Yes, next. Essential elements. This must be original or new, must be eye appealing, not publicly disclosed, distinguishable, not obscene, capable of being made and sold separately. Protection period 10 years. Of course, it can be renewed. Next. IP overlap. See, overlap and interrelationship between design and copyright. Now, this was discussed in a very landmark case, Microfibers Incorporated versus Girdhar and Company. Design and trademark, Carlsberg Breweries versus Sohm. I'll give you an example which covers all these IPs: patent, copyright, trademark, design. Say, let us take the example of, say, a Maruti car. The technology, if it is unique, is protected by patent if it is an invention. The way in which Maruti is written and the shape, that is trademark. The design of the engine, the technical drawing of the engine is protected by copyright, and the shape and model of each car is protected by design. So that is an overlap of all the four kinds of intellectual property. Yes, next. Now, geographical indications. Sir already said about Kanjivaram silk, Darjeeling tea, Kolkata's Rasgulla, your Midana Shitabog of Bardhaman, but I cannot again withstand the temptation of sharing one incident which I experienced in London. I was staying with a host family, and in the kitchen, I picked up a container of the Darjeeling of a tea, written Darjeeling tea. When I turned the container, below it is written "Made in China." and that was in 1997. So Darjeeling tea made in China. Now this was possible at that time because we did not have Geographical Indication of Goods Act. Now we already have a Geographical Indication of Goods Act in India, which is now enforced, and the first to be registered was Kanjivaram silk, and then Darjeeling tea, and then we have many others which have been registered under the Geographical Indications of Goods Act. Any popular place which is linked to the source of the goods or the service can be registered, and the revenue coming from the sale of that good goes to a community fund. Let me delineate the difference in jurisprudence behind the intellectual property of patent, copyright, trademark, design, and geographical indication and plant variety protection. These are community rights which are protected by these laws, but others are individual rights. And in our constitutional law, in our constitution, we aim for a socialistic pattern of society and not concentration of wealth, as is enumerated in Article 39, small b and small c of the Constitution. This is one area of IP which ensures community rights protection. Yes, next. In India, GI is regulated by the Jurisprudential Goods Protection 1999. Registration is mandatory. Registration is prima facie evidence of validity. No transmission of right except by operation of law. GI and trademark interrelationship. Now, 10 years can be renewed according to statutory provisions. Yes, next. Traditional knowledge. This is one very important area. I know I have almost exceeded time, but then a few more minutes. Traditional knowledge. I have a book published. The book name is Intellectual Property Rights of Farmers. There I have a chapter. The name of the chapter is Traditional Knowledge. Now, there I have shown that if we work out the economics of the biopiracy of traditional knowledge by the pharmaceutical giants, it will be 100 times of the turnover of the IT industry of the world. Now, pharmaceutical companies have patented inventions which are primarily traditional knowledge. Even the ordinary pyrogesic or paracetamol uses traditional knowledge as a raw material without disclosing the prior art. But then now there is a lot of awareness on traditional knowledge. We have created traditional knowledge digital library in India as well as it is there in WIPO. Now any pharmaceutical formulation has to go through this rigorous screening of traditional knowledge. Yes, next. So change has been introduced by the Patent Act. We must now disclose the prior art if there is a traditional knowledge. Another law has been enacted, the Biopiracy, the Plant Variety Protection and Farmers' Rights Act, Biopiracy and Biodiversity Act 2000. It's the need of the hour to protect our rich Indian resources. Yes, next. IP enforcement and management. Yeah, next please. So how do we enforce the rights created by these statutes or the laws? In the civil court, injunctions, civil raid, there is a very unique Anton Pillar order created by English courts. See, there was a case on these Myco spark plugs. You know, Myco spark plugs in the two-wheelers used for starting the engine. Once this Myco spark plug, they complained that they manufacture only 10,000 Myco spark plug every day. But more than 1 lakh Myco spark plugs are sold in India. So they carried out raids in the form of Anton Pillar orders. What is Anton Pillar order? The court may grant a permission to raid the premise of the infringers and seize the infringing material, both under the Copyright Act and in the Trademark Act. You know, infringing photocopies of costly books is a very common example. In copyright and trademark, we have criminal remedy also, which involves imprisonment, fine, seizure, and forfeiture. Technological protection or administrative control is holograms, watermarks, and encryption. Yes, next. It's your idea. Protect your intangible assets. Awake, aware, exploit appropriately, and get recognition. National IP Policy 2016. Yes. Thank you. Thank you very much for the opportunity. Now, if anyone has any question, I will try to answer to the best of my ability.
Thank you, sir. It's a very good session, and you have covered all the elements in a very lucid manner. I just check the chat box if there is any question. No, there is no question in the chat box. I request all the participants, if they have any question, they can ask to sir, and sir will answer the questions. If anyone interested.
Hello. Hello.
Yes, sir, please.
Yes, Prem Kumar sir. Sir, I am from Banwarilal. Is there any concession granted by the government for MSME industries in registration of patents?
Concession?
Yes.
Concession
Registration fees or something like that. Registration fees or something like that. I have learned that 50% concession is given for
waiver of registration fees.
Yes.
Yeah, they are there. That is for certain categories of inventors. There, I'm not completely aware about it, but there are certain incentives and concessions for inventors, especially for researchers.
If anyone else? I think not. Sir, I have a question. Sir, yes, in our student days, and now the students are always taking the xerox of the different books. So, yes, what is the thing of this xerox from a book or anything from the Central Library of our University of Calcutta or different universities? Some eminent books are there. They allow us to take the xerox. So please say something about this thing.
If you have gone through the rules of the library, there are certain strict rules of taking xerox.
That's the rule of the library, but we are.
What is the jurisprudence behind the rules? If you have only one copy and the copy is not available in the market, then only you are allowed to photocopy the entire book. Otherwise, you are not allowed. Now,
no, that's the thing. But sometimes we take the xerox of different books for learning. So,
under section 52,
infringement of copyright.
Yes, under section 52 of the Copyright Act, the fair use doctrine is there. If you use it for academic purpose, if you use it for disseminating knowledge in the class, a few photocopies, if you may take, it will not infringe copyright. But if you commercially exploit, it will be infringement of copyright. Okay. So you are photocopying a book and selling it, like the many photocopying centers are doing everywhere. You know,
yes,
there
sir,
are often
they xerox it completely and make it a complete.
Yes, they bind it and sell it, especially the medical books which are very costly.
Sealdah station area, it's absolutely available. It's freely available.
Yes, that is clear violation of copyright.
Exactly. Okay, sir. Thank you. Now I would like, I think nobody has any other questions to sir. So
yes, there was something asking for Creative Commons. There was somebody who was asking about Creative Commons.
Creative Commons.
Yes.
And one person asked, sir, why Vishwabharati got 10 years more in case of Tagore's literature?
10 years more.
Dr. Anup Kumar Raut. Yes.
No, I am not aware of that. I'll have to then look up. Maybe there was some reason. I am not aware that Vishwabharati got 10 years more. But then this Creative Commons, the question who was asked, see, primarily intellectual property right protects individual knowledge or individual creativity. But then Creative Commons is a concept which is internalized in geographical indication, in community sharing of knowledge. These are jurisprudentially two antagonistic concepts. But then certain IPR laws, they protect community rights also, like the Geographical Indication of Goods Act, the Traditional Knowledge Law, which is yet to see the light of the day, or the Plant Variety Protection. But then primarily intellectual property rights protect the individual. And that's why some people, some experts in the field of economics, they discourage intellectual property right for a socialistic pattern of society because it creates the gap between the haves and the have-nots. But then it has got many advantages also. And the best advantage is management of knowledge, or knowledge economies management. And therefore, subject to proper regulation of the state within the constitutional limitations, intellectual property right is inevitable. Thank you.
Okay, thank you, sir, for such an enriching session. Now I would like to Professor Arindam Das to give the...
No, another question was there from Mr. Ahmad. Sir, if you kindly make the question clear.
Yeah, what is the question?
Sir, if take concurrence with me on transfer.
If you have any question, please unmute yourself and ask directly.
Yes.
Yes, Professor Ahmed.
If you have any question, please unmute yourself and directly ask to sir. Sir is there to answer the question.
Sir, good afternoon, sir.
Yes.
Good afternoon, Professor Ahmed. Yes.
Sir, myself a student of yours, sir.
Oh, that's what I am seeing you. I am thinking of actually, you were in Mohsin College, na? What
yes, sir.
You are in BB College now?
Right now, sir, I am serving as a manager finance in DVC, Damodar Valley Corporation, sir.
Okay, congratulations. Very good, very good.
Thank you very much, sir. Sir, I was asking that when I write concurrences in some files,
yes,
and I take Xerox of that for future references, can I take it with me on my transfer?
No, see, this is not related to copyright. What you are saying is that is under the Official Secrets Act. That law is a different law.
Okay, sir.
That is a different law. For that law, we need a separate discussion. There is a very important debate going on in the Supreme Court whether file notings, they come under the Right to Information Act or not. Now, if somebody asks for that information under RTI, you shield that information under Official Secrets Act. If it doesn't fall under Official Secrets Act, you can take it. If it doesn't fall under Official Secrets Act, you cannot take it. Okay?
Okay, sir. Okay, thank you very much, sir. Thank you very much, sir.
Thank you. Anyone else? Anyone have any question? I think not. Okay, so now I would like to Professor Arindam Das to give the vote of thanks.
Okay, thank you. Thank you, Shantanu. Good afternoon, everybody present here. So we have come to an end of this one-day webinar on the intellectual property rights. So on behalf of Indian Accounting Association South Bengal Branch, BB College Asansol, and also on my personal behalf, I take this opportunity to propose a vote of thanks for this event. Firstly, I express my sincere thanks to Professor Amitava Basu, Principal, BB College Asansol, for collaborating with our association to organize this webinar. We really appreciate Professor Basu, a very dynamic principal, for arranging this webinar within a very short notice during this festive season. And without his wholehearted support, this webinar would not have been successful. So we look forward for this type of collaboration from him in future program of our branch as well. Next, I express my sincere gratitude to Professor Joydev Sarkel, who happens to be one of my beloved teachers, Honorable President, Indian Accounting Association South Bengal Branch, and former Professor of Commerce University of Burdwan, for delivering the concept note in this webinar. Thank you, sir. And I believe that any knowledge sharing event becomes successful because of its key speakers and the patients participants, as they are the lifeline of any event of this kind. So we are really thankful to Dr. Taraknath Sahu, Associate Professor, Department of Commerce, and Head of the Department of Business Administration, Vidyasagar University, and Dr. Prem Kumar Agarwal, Head of the Department and Associate Professor, PG Department of Law, Hooghly Mohsin College, Chinsura, for their wonderful insights and critical review of this topic. We are really enriched by their deliberation. On behalf of Indian Accounting Association South Bengal Branch, BB College Asansol, and also on my personal behalf, we appreciate and thank Dr. Sahu and Dr. Agarwal for sharing their views and enlightening us on the topic of the webinar and making this event a highly successful one. And I would also like to thank the members of the organizing committee, namely Dr. Amolendu Samanto, Assistant Professor, Department of Commerce, BB College Asansol, and convener of this program, and Mr. Ovijit Chakraborty, Librarian, Central Library, BB College Asansol, and Organizing Secretary of this program, for their active and wholehearted support of this program. I would also like to thank the members of the technical committee, namely Dr. Arnab Ganguly, Assistant Professor, Department of Zoology, BB College Asansol, Muhammad Arif Akhtar, Assistant Professor and Head, Department of Commerce, BB College Asansol, Mr. Shantanu Mollik, Assistant Professor, Department of Commerce, BB College Asansol, and Ms. Saroj Mahato, SSCT, Department of Commerce, BB College Asansol, for rendering various technical support in this program. And I express my sincere gratitude to all the EC members and other members of Indian Accounting Association South Bengal Branch, particularly Professor Joydev Sarkar sir, Professor Sudipti Banerjee sir, and Professor Arindam Gupta sir, for their sincere support in this type of knowledge spreading activities and event. And last but not the least, I sincerely thank all the participants for their active participation. So, with the permission of the organizers and the speakers and the chairpersons, we are closing the session. Thank you. Thank you all. Thank you.
So much.
Namaskar.
Thank you.
To all.
Shall I share certain things, sir? I'm Captain Rajiv Singh, Principal SSR College, Silvassa speaking. Will it be possible? If you permit me, then I will talk to you.
Please, sir, please.
Yeah, thank you so much. I'm Captain Rajiv Singh, Principal SSR College of Arts, Commerce and Science. One thing which is as a right platform where I has to be share that the patent or the, as far as the copyright is concerned, many people may understand this and they are working on this sector. The patent is also possible in the social science sector, in Indian patent especially. So those who are interested on that regarding their research publication is concerned, so patent is also possible. So if anybody is interested to know, and if you may give certain opportunity in any other time, because you have already closed the session, so I am interested to share that information. By the time I'm sharing in the chat box my mail ID, and the rest of the things we may be discussed in future. Thank you so much. Your program was very nice. The whole time I was in the program and listening a lot. Thank you so much.
Thank you, sir. Thank you.
Thank you. Okay. Now may we close? Arindam Das sir?
Yes, of course. Thank you.
Okay,
thank you very much.
Thank you.
Thank you.
So now I request the admin to end the session.